Hi, Andrew. Sorry to bother you. Just wondering, are they going to put their video on when they're ready to see us?
I'm not sure. It does look like Mr. Freehoff has made it into the Zoom call. So I'm sure he'll be presiding and let us know a little more instruction here in just a few minutes. But it does look like we are going to move forward with the calendar this morning.
Okay. But they'll turn their video on, right? Because I can't see anything, but it says my camera's on.
Yeah, I can't promise whether they'll turn the video on or not. But I think either way we'll get the instructions just over the audio.
Okay. All right. Thank you.
All right, good morning, everyone. This is the staff attorney for Judge Krause. Apparently,
Morning.
this is our civil default calendar. I think at the current time, there's actually only 6 or 7 matters. The judge is logging on, so if you'll just please remain muted and then unmute when she calls on you, and she'll take the calendar and then we'll get underway.
Good morning. Thank you all for being here. I hope everybody has been able to dig out of whatever ice and stuff everybody had to deal with. We have a hopefully pretty short calendar, and we'll just run through it real quick. First position is Noor Panjani versus Mayor Jules.
Your Honor, good morning. Jordan Foreman here for Noor Panjani. I also have a client representative with me, Nadia Popatia.
Okay, thank you.
Thank you.
How long do you think, I've reviewed, obviously we sent out a motion for you to file a default judgment. I've reviewed it. It does appear that the defendant is in default. But in terms of the damages that you're seeking, how long do you think any presentation to that effect might take?
So, Your Honor, I heard from Mr. Freehoff yesterday in response to a question that this is just on attorney's fees.
Yes, sir.
I have a couple of different avenues to pursue, but even then, 5-10 minutes, I would think.
Okay. Thank you.
Your Honor.
And is anyone here on behalf of Mayor Jules or Samir Grover?
No, Your Honor, and he has been copied. And Mr. Freehoff can verify that on every email I've sent to the court. He's been copied. He is aware of this hearing. He's talked to me, but he's not here.
Okay, thank you.
Thank you.
Flower Magazine versus Young and Meath.
Yeah, good morning, Your Honor. My name is Andrew Suarez. I represent the plaintiff, Flower Magazine.
Okay. And do you have anyone here on behalf of, obviously I understand it appears to me that Young and Heath may be in default, but have you heard from Young and Heath? Is there anyone here? Were you expecting anyone here on their behalf?
Not expecting one. They have failed to engage at any point in the litigation. So at this point, we have no expectation that they'll appear today.
Okay, thank you. Next up is Inman Station Homeowners Association versus Carlos Labres.
Your Honor, Laura Horlock here on behalf of Inman Station.
Hi, Ms. Horlock.
How are you, Your Honor?
Good, how are you?
I'm very good, thank you. This is a condominium association claim. The damages are liquidated. We have submitted a motion for default, including an affidavit from the property manager with the damages. I have submitted an affidavit of attorney's fees. I have one change to that affidavit. I found some fees that shouldn't have been billed to that file, so I do have a change to that. But other than that, we're ready whenever you're ready to hear from me.
Okay, thank you. And I had already looked over, I think, a proposed order that you had sent. So if you need to either give me a different number or give me just a new order with different numbers in it, either one is fine. And we'll walk through that in just a moment. Willie Harris versus Marta.
Yes, hi, good morning, Your Honor. Latasha Barnes on behalf of Mr. Harris.
Hi,
How
Ms.
are
Barnes.
you?
Good, how are
Yes,
you?
good morning. Good. Getting through this hectic week. But but yes, Mr. Harris is here present. We and I believe Ms. Shockley is here as well.
Okay. Hi, Ms. Shockley, how are you?
Good morning, Judge Cross. Yes, Nicole Shockley here on behalf of MARTA. We actually have filed a motion to open or set aside default. We
Right.
filed back on the 17th. So I wasn't sure if
Well,
you
I
wanted to-
actually did see it. The concern I have is that while the motion recites that costs have been paid and that an affidavit has been filed, I can't locate any document or record indicating the payment of costs or the actual affidavit that you're referencing. And the case law is pretty clear that if default isn't opened in the specific structural statutory way that's required under 91155, then the court doesn't have jurisdiction to open your default. I'm perfectly happy to do so. It's clear that the parties probably want me to, particularly given the prior case that really should be the case that's in front of me, because it should have been transferred from Clayton County. But for now, there is still a motion for default pending, and there is a motion to open default pending. I'm just not sure that motion to open default is entirely complete. It may be that I've just overlooked anything. It may be that the clerk hasn't updated their filings to reflect the payment of those costs or to reflect the filing of an affidavit. But that's where I'm stuck, because the other issue is, of course, this case shouldn't exist had the Clayton County case been transferred correctly. Ms. Barnes?
Yes, Your Honor, I didn't want to interrupt you, but so the case is actually dismissed in Clayton County. And that's why we had to file an act because it was never transferred and it was dismissed. It's dismissed in Clayton County. So that's why we had to file a new action in Fulton County Superior Court because it wasn't transferred. And so, that's when it was refiled. It was resent as far as by personal service to MARTA. After
No,
30
I
days.
understand all that, Ms.
Yeah.
Barnes.
Right.
The issue is when the court looks at my review of it in terms of when, put it this way, a well-founded, statutorily supported motion to open default in this circumstance, probably likely to be granted. Can't say I definitely would, but probably likely to be granted, given the fact that there's no prejudice to anyone and Ms. Shockley is here. I will say, I have we may need to have a separate conversation amongst the lawyers, because
Yes.
I'm not sure if that case has been dismissed. I don't know. Was this case filed as a renewal action? I'm a little confused
Your Honor.
on some of those issues. And so
Correct.
we may need to hash those issues out, but all of that's a long way of saying this. I'm not going to grant a default judgment today.
Understood.
I may entertain doing that, but what I think I'm going to do is, because the motion to open default was only recently filed, and I understand it to be opposition to the motion for default, I'm going to give that the 23 more days or whatever it needs for you to respond. I can set it for hearing earlier than that if you want me to, but it will just be this case focused on that issue of default, because there seem to be some procedural issues between the Clayton County case and this case that I don't quite understand about about when and how this case moves forward and what to do with it. So that's my suggestion.
Oh, Your Honor, yeah, that's what I was going to say next. I was going to ask for time to respond to the written motion because we just got it yesterday filed. I understand that it was filed on the 17th, but we just got it via Odyssey yesterday. So in order to have time to, because we do want to respond in writing to that motion, and in order to be heard on that and, retain our position that a motion to default should be in place.
Okay. But it's certainly fair. Ms. Shockley, your thoughts?
Yes, I just wanted to address like two quick things. I believe the affidavit was filed as an exhibit in the motion. So
okay. I will go back and look again.
Yeah, I will double check on my end as well as with the payment. Is it okay if I send the email receipt?
Absolutely. It's fine for you to send an email to Mr. Freehoff whatever documentation you have of payment, because it may just be that the clerk hasn't updated the financial information that's visible to me in Odyssey, given the delay, to reflect their receipt of that payment. So, okay. Well, then what I will do is I will await Ms. Barnes or Mr. Harris's response from Ms. Barnes to the motion for default. The motion to open default. And then I will likely set a hearing if the deadline is February 17th. My guess is that I will probably call you guys in just by Zoom for something maybe that week after February, just shortly after that 30 days has run. So, and if Mr. Harris files a response sooner, I might pull you in. If the briefing is complete at that point, I might pull you in sooner. We'll give you notice. But you can expect it will be sometime in mid-February.
Okay. And you said the response is due by, I'm so sorry, Your Honor, February 16th?
If it will, I mean.
It'd probably be
If
earlier.
it was filed on the 17th.
Yeah.
You'd have 30 days, which would be the 16th, but then you get 3 days for mailing. So you do your own math, but I will await the filing of a response. And once a response is filed, y'all can expect that we'll have a hearing on it shortly thereafter.
Okay. Thank you so much, Your Honor.
Thank you.
May we and my client be excused?
Yes, you may. And Ms. Shockley, you may as well.
Thank you.
Thank you.
Stay safe.
Thanks. You all too. Lakeside Preserve Homeowners Association versus Renee Reynolds. I mention it only because in case number one, anyone is here, and number two, I was advised that the parties had reached an agreement and submitted a consent order, but my review last night didn't indicate that a consent order had actually been submitted or filed. Mr. Freehoff?
I'll look into that, Judge.
Thank you. Inverness Homeowners Association versus Jeffrey Fainstock.
Good morning, Judge. Beth Taylor here for the plaintiff in that case.
Hi, Ms. Taylor.
Good morning. It is a simple default for unpaid homeowners association assessments. We filed a motion for default with the court on the 21st. We haven't gotten a stamped file copy back, but I know the court's been backed up because of the weather. And I do have a witness here, should you want to hear from her. And we're ready to go. Should be pretty straightforward and simple. My only ask, Judge, and I hate to do this, but I'm going to, is I have a Zoom mediation set for 10 today. So if you could bump me up a little to the top of the calendar, I'd appreciate it.
I understand, Ms. Taylor. Thanks for letting me know.
Thank you.
And then Tidal Wave versus Erica Brown.
Good morning.
Who do I have here on behalf of Tidal Wave?
Yes, Ted Spalding on behalf of Tidal Wave, Your Honor. Good morning.
Hi, Mr. Spalding. And do I have anyone else here on behalf of Ms. Brown or the two other defendants?
Yes, Your Honor. Brandon Wagner for the two other defendants.
Hi, Mr. Wagner.
Good morning.
Yes.
Okay, so I spoke to Mr. Spalding yesterday. I completely miscalendared Beacon's answer deadline. But I did pay costs this morning. I have a receipt with me, and I believe Mr. Spalding is in agreement that we would set aside whatever default technically exists against Beacon, and then we can move forward.
Right, and that's what I expected. The motion for default that had been submitted regarding Ms. Brown appeared to be in order. I was happy to go ahead and enter that. It was for liquidated amounts, and that was all fine. I think Mr. Freehoff must have communicated that to y'all, that was the only reason I didn't excuse you from today's hearing, was to make sure that T was crossed and that I was dotted. And given the filing date of the other proofs of service and the fact that you were representing both, I certainly understand how it happened. But I don't want a situation to happen where y'all get to a judgment, end up on appeal, and then somebody in the Court of Appeals says, well, the court didn't have jurisdiction to do any of this. So I obviously assumed y'all would just fix it since you filed an answer, and obviously Mr. Spalding is ready to litigate the matter with you. So if y'all could just take care of that and file whatever, and you're still within the opening as a matter of right. So it's just a matter of you've already paid the cost. It's just a matter of filing a notice that you're opening as a matter of right, and then that will take care of that issue. Beyond that, the default as to Erica Brown did appear. Everything was in order. I think I've already reviewed and approved that order. and we'll get that on file for you.
All right, great, Your Honor. Thank you so
Okay.
much. And Mr. Wagner, just for the record, his representation is correct. We have no issues with the opening of default. There's no prejudice, even if we were outside of the extra 15 days. So we're good there.
Okay, excellent. Well, thank you both. I appreciate it.
Thank
Thank you,
you.
Your Honor.
Have a good day.
You too.
Okay. Let me go back real briefly to Mr. Suarez and Flower Magazine. So, Mr. Suarez, the reason you had submitted an order, but the reason I didn't just sort of sign and send you on your way is there are a couple of issues I was wondering if you could get if you could figure out an answer for me, number one. And number two, you had not presented in any form any damages that you had. And so the proposed order that you submitted looked like you were like, okay, well, we'll have a hearing on damages, which is fine. I'm prepared for you to go forward with that if that's the case. But one thing I wanted to ask you is, my review of your file does not indicate what efforts were made to secure actual service at the registered address of the corporate defendant before you resorted to the Secretary of State service, which the Secretary of State service seems valid in terms of it was done and it was properly certified and all that good stuff. But the two questions that I had when I looked at it is, one, there's nothing that I see, there's no non-S service or anything like that indicates an effort to serve the corporate defendant at the registered corporate address before, and I think the case law and the statutory law is pretty clear. It can be any reason that you can't secure service at that registered address, but it has to be demonstrated. And it may be that you did demonstrate it to the Secretary of State, just not to me. I just haven't seen anything in the file that would demonstrate that. Can you address that for me briefly, Mr. Suarez?
Yes, Your Honor. Young and Meath Homes has a registered agent. Her name is Tanya Barker, or allegedly Tanya Barker. She is no longer at the address listed in any capacity. It is an empty space. We have Jeff Dolbier. I believe in the packet that was submitted to the Georgia Secretary of State, which would be reflected in what we filed with the court. We do have an affidavit that he attempted service on the corporate agent here in Georgia, was unable to. But I'm happy to file that separately if that's, would help you out.
Okay. And if you're representing that to me, I have no problem with it. It was just that it was not readily apparent from the docket when the certificate of service that was filed in December is it was not readily apparent to me from that the efforts that had been made, but you've addressed them, and that's fine. The second issue I had, and I was wondering if you could, and I don't know the answer to this, and my industrious effort at research has not answered it, which is, to what extent does the Secretary of Service clearly says that the 30 days to answer runs from the date the certification is received by the Secretary of State, right? Which would have been sometime back in November. But 911-4H also requires proof of service to be filed. And so to what extent does your filing of the proof of service in December, it seems that you and I were both on the same page, and your order seemed to indicate that the proof of service, the 30 days would run from that date, which would be December 19th, in which case, while Young and Meath Homes would be in default, they would still be within their 15 days to open as a matter of right. Now, if I calculated the 30 days from when the Secretary of State received the certification, which is what 911-4-1 something says, then the default period has closed. What are your thoughts on that?
My understanding would be that this the state law mechanism for entry of a default is similar to the federal, whereas I understood today to be the clerk's default judgment, followed by the entry of default afterwards with proof of damages at that point, which is one reason that I apologize. We have not filed an affidavit proving claims or proving damages at this point, including attorney's fees.
Okay.
So it may be that I just was working from a improper assumption.
Well, no, that's fine. And Mr. Suarez, I'll tell you, as a young lawyer a long, long time ago, I learned that lesson the hard way. Georgia's default rules are quite unique. Having practiced in Florida and in federal court extensively, Georgia's unique in that on the 31st day, you're in default, period. Nobody has to enter anything. You're just in default. And after 15 days pass from that date and you don't move to open default, then the plaintiff is entitled to a default judgment upon proof of damages. And if the damage is sought or liquidated, then you can, whatever. But you need to, I guess my point is, if we're both operating from the assumption that an abundance of caution, I believe that 911-4H has to be read in paramateria with the other service requirements, which means the filing of the proof of service is the relevant date here. Then the only thing you would be entitled to at this point would be, as you pointed out, some sort of order of default, which I don't typically enter. Typically, what I would do is wait until that 16th day after default. And if no one has filed an answer or moved to open default as a matter of right or moved to otherwise set aside default, then I would ask you to provide proof of any damages, and then I would just enter a one-time default judgment.
Yes, Your Honor, and that makes sense. And I appreciate the clarity from you from the bench.
Okay. So then what I will do, Mr. Suarez, is, and to be clear for all of you, I know sometimes it is a little, it might be a little disconcerting because we're sending you orders telling you to file a motion for default, and you might have a different opinion about whether there's a default. And so I understand that might be a little bit counterintuitive when you show up after I've told you to file a motion for default and then say, I don't think they're in default yet. But it's simply a way to make sure that these cases are getting on the calendar. If there is a default, to go ahead and document it and move forward. So I apologize if I've said, come here and tell me about your default, and then said, no, there is no default. What I will do, Mr. Suarez, is recalendar this matter for, I believe it's going to be towards the beginning of February, that 15 days would run. And if we've not heard from Young and Meath Homes, then I would set you on another calendar sometime after that. It'll be that first week probably of February if the time is run. And at that time, you could expect that I would be looking to you for any proof of damages for the entry of a default judgment.
Yes, Your Honor, completely understood, and I appreciate the clarity.
Excellent. Well, thank you so much, Mr. Suarez.
Thank you. May I be dismissed?
Yes, have a good day. Okay. Where are we now? Ms. Taylor, I'm going to let you go since you have to get onto a mediation, and I want you to settle your cases so that you can get them off of my docket. So
I appreciate that.
Yes.
It's my third mediation this week, so it's my theme of the week, I think. But anyway,
Understood.
that's a good thing. Thank you for the courtesy. So, Your Honor, this is a case for unpaid homeowners association pursuant to the duly recorded declaration for Inverness, as well as the Georgia Property Owners Association Act. A foreclosure lawsuit was filed with the court on November 20th, 2024. Defendant was personally served on December 4th, 2024. No answer or responsive pleading has been filed. We filed on behalf of the association a motion for default judgment. And again, I don't know if it's gotten through the clerk's office yet or not. And I hadn't emailed Mr. Freehoff. I have a courtesy copy, but it's not a stamp file courtesy copy because I don't have that yet. So,
and we understood this period of time with the court, the clerk's office having been closed, we kind of understood we're gonna hold our orders and make sure the clerk has a day or so to get the motions on file, so we don't end up with that weird situation in the docket where my order is there before the motion is filed, and your motion still has not been accepted. I expect before we enter those orders, we're going to reach out and confirm with the clerk that those motions have been received. But I've of course seen your motion and your proposed order and reviewed it as well. So.
Okay, and then, I do have a witness if you wanted to hear as to the unpaid assessments, Miss Lindsay Malone. Do you want to hear from her? Or
yes,
just want to hear
very briefly?
Sure, absolutely. Hey, Lindsay, can you take yourself off mute?
Yes.
Can you raise your right hand for the court? Do you swear to solemnly affirm the testimony you give the court today is the truth, the whole truth, and nothing but the truth?
I do.
Can you please state your name for the court?
Lindsay Malone,
And what is your relationship with the plaintiff?
property manager.
As a property manager, are you charged with maintaining the account ledgers and histories for owners within the Inverness Homeowners Association?
Yes.
And are you familiar with the account ledger and history for the defendant in this case, Mr. Fonestock?
Yes.
And is Mr. Fonestock delinquent with the association?
Yes.
And to date, can you share how much he owes the association?
In principal, $1,265.
In addition to the principal, is the association seeking interest on that amount pursuant to the declaration of the Georgia Property Owners Association Act?
Yes.
And how much is that interest?
$112.50.
Okay. Judge, in addition to the principal and interest, the association is seeking its costs of collection, which include its reasonable attorney's fees actually incurred. With our motion, there is that pending affidavit for attorney's fees before the court, and there is a billing statement attached to that affidavit. What I'm going to testify to here today matches that. So on behalf of the association, Winter Capriola Firm Legal Services at the rates of $195, $210, and $300 per hour. These rates are reasonable and customary for attorneys in the Atlanta area practicing condominium and community association law. We have had this file in our office for collections since this case since June of 2024. On behalf of the association, we did a title search to confirm title. We sent a validation notice. We sent 2 subsequent demand letters to defendant. We then checked defendant's bankruptcy status prior to filing a lawsuit, filed the foreclosure lawsuit, had defendant served, filed the entry of service, and filed a motion for default judgment. So from June, in my time today, which is really short, and actually I am not seeking that because the motion was just filed on Monday. So from June 17th, 2024 through today, the association, Winter spent 11.3 hours of time on this case, and the association incurred $2,488.92 in attorney's fees and expenses, and $250.02 in court costs. The hourly rates, work performed, time spent, and total expenses incurred are reasonable and actually incurred. And again, the association is seeking these pursuant to the duly recorded declaration and the Georgia Property Owners Association Act. And finally, as pled in count 2 of the complaint, in addition to a money judgment, the association is seeking an order authorizing its judicial foreclosure of its lien and the judgment against defendant. And by way of history, this is our 3rd time around with this particular defendant, and it's just a cycle where we get a judgment, we ultimately get paid, and then we're here back again in a couple of years. So that's this particular homeowner.
Understood. Thank you, Ms. Taylor. So the presentation you've made appears to be sufficient to me. As I said, I have already reviewed the order, and everything appears to be in order. And so I will grant the default judgment that is sought in the amounts that have been sought, and we will get that order on file as soon as we confirm with the clerk that the motion has been docketed. We will enter that order for you, so you should have it maybe today, but certainly in the next few days.
Okay, I appreciate it. Thank you, Judge. May Lindsay and I be excused?
Yes, thank you both. Have a good
All right.
day.
You too. Bye-bye.
Okay, thank you all for your patience. I appreciate it. And next up is going to be position 1, Mr. Foreman, Noor Panjani.
Yes, thank you, Your Honor. Good morning. What I'm going to do is start from the end to kind of give you a little background and then kind of walk my way back here. I did present a proposed final default judgment to Mr. Freehoff a few days ago, but I've actually prepared 3 of them. And one of them, well, it's always good to be over-prepared rather than under-prepared.
Right.
So one of them assumed a 15% attorney's fee rate. But really, when you look at the contract, and I'll talk a little bit more about that in a minute, it presumes a 33% rate. And then I also prepared a presentation based on actual fees, which are among the exhibits that I presented. Now, looking at the complaint, it does provide for attorney's fees under 13.611. The contract provides for 33%, like I said. So it leaves a few options here. And I'll be happy to put on my witness for as long or as short as you want, but I would say a couple things prior. One, it sounds like some of the other cases on the docket today have very recently filed motions. Ours has been about, I think we filed in early December. one of the things that I realized looking at it is I had not attached the written agreement to the complaint. However, Nadia Popatia, the witness that's here today, did sign an affidavit before the notice of this hearing came out. She signed it, and I probably should have made it an additional exhibit, but it is filed. She signed it on January 2nd of this year. It was probably filed the next day, probably January 3rd. And I think it covers all the facts that you would need to see there. The most important one being that attaches Exhibit 1 to her affidavit is a true and correct copy of the agreement. And that happens to be Exhibit 1 for the hearing as well. It also says that attached as Exhibit 2 is a running summary of sums owed by defendants to plaintiff. And that happens to be Exhibit 5 for the hearing. So these have been presented separate and apart from the affidavit.
I'm looking at them now, so.
Okay. And what I would say is this, it is a liquidated sum. It's really a suit on account, as I think you're familiar with, Your Honor. I have my clients, they sell jewelry. And so, but this person only took one shipment. So the dates, I didn't have to do a bunch of complicated math from various dates. It all stemmed from June 12th of 2022, which is almost 3 years ago. I mean, it's 2.5, 3 years now. So if you're looking at Exhibit 5, it shows that the total is exactly what it says in the complaint, $47,109.99 in principal. The proposed final default judgments that I have prepared have calculated the interest through today. It's at 18% interest because that's what the agreement says. And so then when you come to attorney's fees, it's just calculating off those two liquidated numbers. The two numbers add up to close to $70,000. It's $47,109.99. And then the interest as of today is $22,209.74. So doing quick math, that's $69,319.73. And so then it's just a question of whether we're looking at 15% of that, 33% of that, or actual fees. If you're inclined to hear actual fees, I'll make my presentation. If you're going to work off the contract and either offer the 15 or 33%, again, the affidavit kind of covers most of that, but I'm happy to put up the client to go over that too if you'd like me to.
I don't know that I care which horse you choose to ride, but I think you just have to decide which horse you want to ride. My main concern for default is I've reviewed the file and it appears that the defendants are in fact in default, having been served with jurisdiction being placed here based on the choice of forum clause in the contract. And so it does appear that service happened back in November,
Yes.
that an answer was due in December, and that no answer's been filed and more than 15 days have passed. And so really the issue is, as I understand it, if you proceed under contract damages, whatever percentage you choose, then you're really proceeding under 13-111 and that's liquidated. Whereas if you are proceeding under 13-611, then you need to give me some evidence. And oftentimes I get evidence presented to me either way. So as I said, Mr. Foreman, I don't know that I have an opinion. It's just that you have to pick a horse to ride.
Sure. So, and you mentioned that you get evidence of both, and I was kind of inclined to head that way anyway, Your Honor. And so what I will say is this, the final default judgment that I submitted to Mr. Freehoff will be the one of the three that I do not intend to use. I'll look to the other two because one's a higher percentage and one's a higher number. Frankly, the numbers between the 33% and the actual are not that great, but I'll let the court decide which one it wants to do after hearing about both. So let me, if you don't mind, Your Honor, first, with respect to the 33%, it's there on the exhibit. She's signed an affidavit that says that is the correct percentage. Would you like to hear from Ms. Popatia?
I don't know that I need to because I do have the affidavit. And as I said, if we're treating it as liquidated, because they are contract interest damages under 13-111, then those amounts are liquidated subject to the affidavit that she's provided for documentation of it.
Okay, and just to state for the record that proposed default judgment shows attorney's fees and expenses in the amount of $22,875.51. And I'll be happy to send both of the other drafts to Mr. Freehoff right after we're concluded here. That shouldn't be an issue.
Yeah, please do, because I think the one I'm looking at, that maybe one version that you sent that you said you were not proceeding on, has attorney's fees at $10,000, which must be $10,397.96, which must be a different version.
That's the 15%, and that's why
Yep.
that's not the one I'm going to use, right? Because the contract does say
understood.
33. So the number I just provided you, 22,875.51, that's the 33%, and then I'll get into the presentation here in a second. But if it's at actual, it's $26,842.09. As you can see, it's not a great difference, but I'll proceed anyway since I'm here, and we might as well. So
Go ahead, Mr. Foreman.
all right, thank you. Standing in my place. We believe, as Your Honor stated, we believe we should be awarded the fees and expenses. And really, I think this is a 13-611 argument. 13-111 is under the contract, so this would be a 13-611 presentation as to fees incurred. I've been practicing law in Georgia, have been licensed since 1998, 25 years of experience in litigation. Was with Kaufman and Foreman from May 15th of 2000 till almost the end of 2019, and was a partner there for most of the time. Since December of 19, Kaufman and Foreman merged with Fox Rothschild, which is where I am now. And I've been a partner here for most of my time here, and I've been practicing here for a little over 5 years now. I was lead counsel to plaintiff in this action. I've directed all aspects of representing plaintiff in this matter. Honestly, Your Honor, looking at exhibits 3 and 4, it doesn't really look like I got much help from anybody, but to the extent I did, I supervised every aspect of the litigation. I think I saw a paralegal's entry on there once, but 99% of it's me. So I've now submitted to my court, to the court through my exhibits presented, the billing records. They started August 24th, 2023, when I first took the engagement in this case, and they ran through this past Monday, January 20th, 3 days ago. They were generated by my office in the regular and ordinary course of business. I'm familiar with our record keeping method for purposes of preparing the bills for services we render. The bills are prepared by the firm, personally reviewed by all attorneys who work on the file, including me on this matter, and verified as to their accuracy and content. It's our firm's standard operating procedure and practice to keep track of attorney and paralegal time. The entries that you see on the exhibits were made contemporaneously with their occurrence or shortly thereafter, and they certainly provide the best evidence as to actual time and efforts expended on the matter. My billing rate was $530 per hour through December 31st of 2023. For all of 2024, it was $595 per hour. And in the little time that's been so far in 2025, $680 per hour. I believe my billing rates have at all times been appropriate given my experience level and are commensurate with other people in the Atlanta area of similar experience. And I would say the same for any other attorneys or paralegals that you see on the records. Exhibit 3, I believe, was the fees. 4 actually is the expenses, which were not tremendous. They were under $1,000. But those records were kept the same way as the fees. We track them contemporaneously with when they happen, and we provide them to the client. So as demonstrated by the billing records, the total amount of fees as of Monday on this matter was $23,538. The expenses were in the amount of $788.09. We haven't incurred any expenses since Monday, so that number is still accurate. I did calculate using my own ability to see the hours I put in the last 3 days using our system. And what I see is that on the 21st, it was 1.6 hours. Yesterday, the 22nd, 1.1 hours. I'll estimate an hour today, and if it's short, it's short. That's okay. So the total since Monday is 3.7 hours at $680 an hour. So that adds $2,516 to the attorney's fees, and that brings the attorney's fees total to $26,054 even. And when you add that to the $788.09 for expenses, the total is $26,842.09. We believe we're entitled to that under 13-611, and as a part of the default, as Your Honor stated, really by the terms of the contract as set forth in the complaint, the principal and the interest are liquidated sums. So if you work off of a percentage, if you use the 33%, then it's based on those numbers. And those numbers will be the same in both, the principal and the interest will be the same in both of the orders that I present to you. But we believe that the fees and expenses actually incurred are $26,842.09.
Understood. Thank you, Mr. Foreman. Anything else that you want to present?
No, Your Honor.
Okay. So as I mentioned, it does appear to me that the defendants have been served and are in default, and that more than 15 days has passed since they became in default, and there's been no effort to open default. And so the plaintiff, Noor Panjani, and if I'm pronouncing that correctly, I'm sorry,
You are.
and Sons, is entitled to a default judgment in its favor in the amounts that you have sought, Mr. Foreman, both the liquidated amounts that are due and owing under the contract, and then the additional, I believe you elected 13,611 fees based on what you've presented here today. And so if you will send me a proposed order, final judgment that has those correct numbers to Mr. Freehoff this morning by Word version by email, then we will go ahead and get that signed and get it on file for you.
I'll do that straight away, Judge. Thank you very much.
Okay, excellent. Thank you very much. Both of you have a good day.
You too. Thank you, Your Honor.
And last but certainly not least, Ms. Horlock, I'm sorry to put you at the end, but thank you for your patience.
No, excuse me, Your Honor.
Yes, ma'am.
I am so sorry to interrupt. You said last but not least, which is where I was, I had called to find out if I was still on the docket. You didn't mention me earlier because they told me to be here at 9 a.m.
I'm so sorry. Can you tell me your name, ma'am?
Yes, ma'am. Thank you. It's Cordetta Spells, Spells. And I probably drove everybody crazy with my messages.
No, Ms.
Spells.
Spells, I'm going to have, I suspect, and Mr. Freehoff is going to confirm for me, that what happened, as you've heard me mention today through some of these hearings, there are cases we have with liquidated damages and there are cases we have with unliquidated damages. And when cases are liquidated, our order sends out a notice. We send out a notice that says, if the matter is liquidated, submit a proposed order and we'll sign it. Mr. Freehoff?
Yes, Judge, this is actually a scenario where the plaintiff's asked to be reset to next week's default calendar. So I need an email address from Ms. Spells.
Ms. Spells, it looks as if the defendant requested a reset to next week.
Well, you mentioned that overlap.
I'm sorry?
No, you had mentioned in one of the cases back there, I'm learning a lot listening to you. Something about the overlap. You said sometimes things are sent out just to make sure that they're here. And I think that's what happened because I paid all of the amount that was owed to Noack and Howard. It was $4,800, including attorney's fees and processing.
Okay, well, forgive me for interrupting you, Ms. Spells, but it wouldn't be fair for me to hear from you substantively about your case because the lawyers for the other side aren't here and they requested a reset. Now, what I would strongly encourage you, just like I would anyone, is if that is your issue, you've mentioned that you believe you've actually satisfied these issues, to try and get in touch with the attorneys before we have the hearing on next week. And then if that's not, if you're not able to speak to them, to just make sure that any documentation you have regarding those payments, that you have those ready to show to me next week when we're all together. But in the short term, if you could provide Mr. Freehoff with an email address so that we could send you a notice of next week's hearing. It will also be next Thursday at 9, just like isn't that right, Mr. Freehoff? Is it also Thursday?
Correct.
Right, but it'll have a different Zoom link and we need to send you that Zoom link and make sure you have it. So if you'll give him that information, then I will hear from you substantively about your concerns when the other side also has an opportunity to be present, okay?
Thank you. I'm so sorry to interrupt there. Please
No, I understand when it's confusing when you think you have to be somewhere and nobody calls on you. So I'm glad you spoke.
Thank you very much. Yeah, it's just Cordetta Spells at yahoo.com.
Okay. All no dot between the two words.
No, just one Cordetta Spells. Yeah.
Cordetta Spells at yahoo.com. All right. Thank you, Ms. Spells.
Thank you all. Have a blessed day.
Thank you, ma'am. Have a good day.
You too.
Ms.
Bye-bye.
Horlock.
Yes.
I apologize. I thought Ms. Spells was perhaps your client representative or something. I wasn't.
okay.
I didn't realize that was separate. So indeed, last but not least, is Inman Station. I'll save you some trouble, Ms. Horlock. I've already reviewed the file and it looks like the defendant was served on November the 20th and service proof was filed timely. Answer was due on December the 20th, no answer was filed, and default occurred on January the 6th, and obviously more than 15 days has passed. Since, January the 6th was the 15th day after default. So you would be entitled to a default judgment. The only issue is the amount.
Well, so Your Honor, we filed the motion for default. You should have received a copy of that. The damages are liquidated. It includes an affidavit from the property manager, Jennifer Brown, verifying the balance owed, and it includes an account ledger. I also submitted an affidavit of attorney's fees, which includes the details and a fee ledger of my fees charged. I would like to make one change to that affidavit. I realized that there is an entry on my attorney's fees for January 9th, 2025 in the amount of $240. That should have been billed to another file. So I would like to, I'm going to reduce my request for attorney's fees by that amount. I've spent approximately my firm, the paralegals and me have spent approximately 9.3 hours prosecuting this case. I sent 2 separate notices to the defendant before we filed the lawsuit. We drafted the lawsuit 3 separate times, or we have 2 separate affidavits of non-service where our process server tried to serve the defendant and was unsuccessful. We sent, in light of that, we drafted and sent a request for waiver of service to the defendant. We sent a different process server to try and serve the defendant, and finally perfected personal service. So we spent a little more time on this than we usually would. I bill at the rate of $300 an hour. I've been practicing since 1991 in litigation and in community association law since 2008. I think in light of Mr. Foreman's testimony that he bills at $680 an hour, and he's been practicing 7 years, less than I have. I think my rate at $300 an hour is a very
Eminently reasonable.
It's a very reasonable rate. So the total attorney's fees I'm asking for, and I will resubmit an updated order with the reduced amount. But so what I have is the principal amount is $3,111.03. The interest is $166.35. The attorney's fees, less the $240 that I discussed, that amount is $2,614.68. And I asked the court to award an additional 1 hour of my time for preparing for and attending this hearing, which would be an additional $300 for attorney's fees. So we're asking the total balance owed $6,192.06.
Okay.
And I can submit an updated order. I can do that as soon as we get off.
Right, perfect. And that was really all I was going to ask you to do, is if you could send me everything that you provided appears to be in order, as I mentioned, and everything is, there is a default, and the attorney's fees that you've submitted are reasonable, including your hourly rate and the time spent. And so if you will send me a proposed order that includes those numbers, we'll get it on file for you.